All right, court is in session. Court calls up the matter of State versus Ferriter. We're hearing a motion to set bond. Let me have appearances, please.
On behalf of the state, Brianna Coakley.
On behalf of Mr. Ferriter, Khurram Wahid, Ferriter is present.
All right, court notes that Mr. Ferriter is present in the jury box. All right, Mr. Wiley, it's your motion. You may proceed.
Judge, we're asking for a bond pre-sentence for Mr. Ferriter. He was charged in this matter by information in March of 22. He was out on bond, on a $50,000 bond is my understanding. From then up until the end of the trial, he never missed a court appearance. He appeared as the court required, either live or by Zoom, for every appearance that was required by the court. Currently, the sentencing is set for November 16th. It's less than a month away. It would be of great assistance to the defense for Mr. Ferriter to be out of custody in order to assist in our preparation for the sentencing hearing. He currently is able to put forth a bond package of $100,000 monetary bond, surrender his passport, and provide a and is willing to use a GPS monitor, level 1.
Okay. Anything else, Mr. Wiley? Do you intend to put on any evidence in regard to this motion?
I am not.
Okay.
I'm relying on the fact that the docket reflects the fact that Mr. Ferriter has never missed court. The purpose of bond is to continue to make sure that the defendant appears for court. There is no doubt that Mr. Ferriter is going to appear for his sentencing hearing. He's appeared all the way through and continues to intend to comply with all of the court orders. I would also point out that he does not have any custody of the children, and therefore there is no issue there. We are, as I said, preparing for testimony for the sentencing, and we may be needing to prepare his statements as well.
All right, so even though you're not going to put on any evidence, let me have you at least speak to the issue of flight risk, because that's obviously the central issue to a court anytime you're considering post-conviction release, whether it's pending sentencing or even after or pending appeal. I don't know anything about the defendant's background in the sense of what his financial resources are, what his travel experience is, that guides me and informs me as to whether he could be a flight risk or not. And so are you going to give me any enlightenment as to that, through the evidence? Because the cases that I've read on this tell me that I can't just draw a conclusory determination that a defendant is a flight risk, that I have to base it on specific evidence. But in this type of motion, the motion burden would be with the defendant, right? You agree with that?
I do, which is why, in order to deal with that issue, because from our position in terms of a bond request, we'd have to be able to deal with that issue in our bond package, of which that includes surrender of passport, which I'm prepared to do today. I have it with me. I'm also be able to tell the court where he'll be residing. I don't want to do it right now in open court, the address, but it would be in Palm Beach County, so he would be under the jurisdiction of this county. He would also, as I said, have a GPS monitor level 1, and so all of the issues related to flight risk can be managed through what I've been proposing. I do think that, and I'm sure the court is aware that he has lived in another state at some point. So in terms of travel and that sort of thing, there's no intention to leave the state of Florida, in fact, not even leave the county of Palm Beach.
All right, anything else, Mr. White?
No, not at this time, Judge.
All right, Ms. Coakley?
Your Honor, there is one case that I was able to find on it. I'll provide it to the state, which is Kraft v. State, and that case basically stands for the proposition that it's in the discretion of the court. I can provide it to you.
No, I have it. I already have it, and I've read it.
And the things that Kraft says that we look at is flight risk, as well as, they said that was an important consideration, was whether or not there was a mandatory prison sentence in this case. There is.
Speak to me on that, because we're obviously not at sentencing yet, but in looking at Kraft and also, I think it was the Cheatham versus Novell decision, one of the things that I can consider is whether there is a mandatory sentence involved, because that informs on the issue of potential flight risk. So tell me what, without obviously us being at the sentencing hearing at this point, tell me what the mandatories are that we are looking at
The
here.
bottom of the guidelines in this case is 75 months.
75 months. So that's a little over 6 years.
Correct, Your Honor. And obviously, Your Honor has discretion all the way up to 40 years in the Department of Corrections, which is a substantially significant posture than when the defendant was on pretrial, especially since the state, first of all, he's convicted, and second, there's additional charges here. He was on pretrial release as to 2 charges. Immediately before trial, the state added a 3rd charge. So that's a fundamental difference in his position, besides the fact that he's been convicted, and now that there's a mandatory prison sentence. That creates a substantial risk of a flight risk, Your Honor, that was not present before, and also leans against that it would be appropriate for pre-sentencing release. I think, Your Honor, as Your Honor knows, it's an incredibly rare thing for there to be a pre-sentence release. There are very specific guidelines that dictate post-sentence release, but this type of posture is incredibly rare, and I cannot think of a case in my career where there was a pre-sentence release.
I tend to agree with you, but in anticipation of this hearing, I did a significant amount of research myself, and I was already familiar with the Kraft decision.
It is in your discretion.
Yeah,
that is the accurate statement of the law. You could do it.
It is, and let me tell you, I don't know if you reviewed the Batiste versus State decision. That's at 134 Southern 3rd, 1025. And this is a decision that, because my general feeling of the law was what you've just stated. It is exceptionally rare to grant bond pre-sentencing. But in the Batiste case, the court made a couple statements, and one of those statements that gives me some concern in terms of what I have to decide here is the exercise of that discretion. And basically, the Batiste decision said that a trial court judge does not satisfy the requirement to make written findings in support of denial of post-trial release, because if I deny this, I have to do a written order, by merely making conclusory findings unsupported by the record. Rather, the rule governing such motion in the Youngins decision, which is where the post-conviction guidance comes from in terms of bail or bond pending appeal, on which the rule is based, embody the Supreme Court's determination that decisions regarding post-trial release must be reasoned, and therefore a mere verbatim recital of the considerations in Youngin will not suffice to fulfill the requirements. And so what I think that tells me is I can't just draw the conclusory or make a conclusory allegation that he's a flight risk. I have to be able to point to evidence in the record that would substantiate the conclusion that he's a flight risk. And so with that in mind, tell me from the state standpoint, and I think you've already pointed to one, the minimum that sentence that he's facing, the guidelines, and then the maximum up to 40 years. Are there other factors that would weigh in support of the state's position that there's additional evidence like not sufficient ties to the community, world traveler, those kinds of things that would affect my decision?
There are, Your Honor, and I think that part of this is it's the defense's motion, and so they should bear the evidentiary burden of establishing that he's not a flight risk. He came to trial and came to prior court dates is not, I think, a sufficient legal basis for Your Honor to conclude that he's not a flight risk, right? They have the evidentiary burden before then that the state has to rebut that. But I would say based on the information that we have in this case, the defendant has huge international contacts. His very close friend flew from Australia for the purpose of testifying on his behalf. And so he has contacts throughout the world who have made extraordinary efforts to be in support of him. In addition, the defendant has resided internationally. He resided in Spain for a period of time during the time when with the children at a certain point. And I also think, as to say that he's a flight risk, there is no local residence. The defendant, the home that was at issue in this case was sold. Based on the information the state has, we have no indication that he owns any local property in Palm Beach County. The defense has not provided the address of where he will be living so that there can be any checks as to the ties there. He also is not the one that posted the monetary bond in this case. The bondsman was supplanted in this case by a friend who posted the entirety of the bond. And so the financial risk here is not the defendant, it's one of his supporters. And so that is a consideration as to whether or not a bond would be an appropriate check here, because he doesn't have a local residence, he doesn't have any financial involvement in the bond if it's being posted by a friend. All of those are considerations. In addition, the defense has articulated that he doesn't have any continuing contact with the children. That is just not true. The youngest child in this case was adopted by his co-defendant's parents, and he's had continuing contact with that child even since he's been in custody. And so there is a substantial risk, and I think it's important to note that that child was removed from his custody by the Department of Children and Families. That dependency case closed when the adoption took place. And so there's a risk even that he'll have continuing contact with a minor child, or even be living in a home with a minor child. We don't know that because the defense hasn't provided any evidentiary support for where he'll be living, who he'll be willing left, and whether or not only we can prevent him from fleeing, but we can protect the community from someone who has now been convicted of multiple crimes against a child. And so based on all of that, I don't think that they've reached their evidentiary burden, but there's substantial support for the idea that he has a risk, especially in consideration in light of the bottom of the guidelines in this case in a mandatory prison sentence.
Okay, all right, thank you. Ms. Coakley, rebuttal, Mr. Wahid?
So I'm familiar with Kraft. The issue in terms of burden to start with is it's our burden to deal with the securing of his return to court, which is the entire purpose of bond. And we're dealing with that through the issues that we brought up as to surrendering his passport and a GPS monitor, and that he will be residing in Palm Beach County. In terms of the address, I'm happy to provide the address to the state. I'm happy to have them go and do whatever they need to do to make sure that there's no child at the house or anything of that nature. In terms of the bond amount, there's nothing in the case law that says who puts up the money. That was irrelevant. And in terms of who...
Why is it irrelevant? Because bond is typically, it creates financial exposure for the defendant putting up the bond, or for his family that's putting up the bond. If he's not the one that put up the bond, why isn't that a factor I can consider in the sense that the normal scenario where the defendant would feel the financial pressure of the bond doesn't exist here if someone else has put it up?
Well, because first of all, even if as to the previous bond, this is what we're talking about, right? The $50,000 bond, sure. So clearly, he did continue to come to court on that. So the evidence in the record is that it did work. He did continue to come to court all the way through trial. So there's no issue that, I don't think the state's even saying that he missed a court date. So there's no issue that that didn't work. Of course it worked. We know. We went all through the process.
Except the scenario is radically different now, post-conviction. Do you agree with the representations by Ms. Coakley that the defendant has sold his home in Jupiter that was his residence at the start of this trial, and he no longer owns a residence here in Palm Beach County?
One moment, Judge.
And while you're asking, meeting with your client, I'd like to also know, do you agree with Ms. Coakley's representations that the defendant has lived in Spain for a period of time with his children?
So as I think it did come out even in the trial, and so the state knows that Mr. Ferriter did live in Spain, but that was in 2009. And that issue of international travel is remedied by both the surrender of passport and a GPS level 1 monitor. In terms of does he own a home, he does not at this point own a home. It is not the first time somebody who doesn't own a home, though, can still, live somewhere and not be in custody during the pendency of the case. We're looking at a relatively short span of time that we're asking for. We're asking for from now till November 16th. So I think that steps can be made to deal with any additional concerns the court may have, but flight risk should not be one, because with no passport and a GPS monitor, the court would be informed of any violation of that situation. And if he's in Palm Beach County, he's under the jurisdiction of the court the entire time. So I do think that is remedied. In terms of the issue of is the mandatory sentencing, my understanding of the years I've been doing the mandatory sentencing, what we're talking about is if there's a minimum mandatory, statutory minimum. There really isn't here. There's a guidelines range, and the bottom of that guidelines range is, as the state just put out. But
Do
that,
you agree that it's 75 months as represented by Ms. Coakley?
I have no idea what it is.
No reason to,
I have no reason to doubt it. I just don't know what it is. I let the state score, folks. I don't really bother. But I will say this, that the court can downward depart, the court can upward depart. The court has full discretion at sentencing. The court knows that. So there's no minimum mandatory in that sense. So we've dealt with both the issue of flight risk. We've dealt with the state's issue as to that the circumstances have dramatically changed. The only additional charge, which was put on, I think, a week before the trial, was the neglect charge, which is an F3. It doesn't substantially change the score, quite frankly. And I do think that it's important to note that we're looking at a very relatively short time frame that we're talking about before we get to sentencing.
but it's a relatively short time frame that follows the conviction and adjudication by the court on the charges. So I know I'm telling you what you already know, that radically changes the calculus between pre-conviction, pre-trial, and the considerations that I look at post-conviction. I mean, the risk of flight is always an issue even in pre-trial, but once the adjudication occurs, it's something that we really have to look at that point, because now we've passed the precipice of an adverse jury verdict at this point. So any additional argument that you wish to make on any of the points that we've raised? Any other factors in Youngins that you would ask that I consider? And I get that Youngins is the standard for bond pending appeal, but some of the cases I've read said the same considerations are appropriate for bond pending sentencing as well.
Well, I think Youngins and his progeny really also talk about the fact that what is the purpose of the bond? The purpose is to ensure the defendant comes to court when the court requests it. And I think you can look at, in terms of evidentiary value, the record in this case going back to March of 22, where, as I've said a few times now, he's never missed a court appearance. I think that the hypothesizing of what might happen should be better predicated upon what's already happened. And so we know he's come to court. We know that whether he was in state or out of state, he made those appearances. In terms of the bond, whomever put up the bond in the past doesn't have to be who puts it up in the future. If the court wants some assurance that Mr. Ferriter is participating in putting up money of his own in this bond, we can put that as a condition. But I do think that it would be of great assistance to the defense to prepare in this short span of time for the sentencing to have better access to Mr. Ferriter between now and November 16th.
All right, thank you. Court is going to take this under advisement. My review of the case law and of the rule tells me that I need to make specific findings in regard to my ruling on this motion, so that's going to require that I put together a written order, and I will move promptly to get an order out as quickly as possible, but it's not something that I can rule from the bench without doing what the cases tell me, and the rule tells me draft an order with findings to support whatever my ruling is. So anything else I need to address before we recess on this hearing?
No, Your Honor, but if you're at all inclined, the state would absolutely recommend that he can have no contact with children and no contact with the co-defendant, I
Okay.
think that would be very important to the state.
Okay. All right, good enough then. Court is in recess. Thank you.